the agenda. First, I'd like to welcome our new member, Josh Johnson.
Holden.
Josh Holden is a new member, an attorney from Knoxville, and congratulations and welcome aboard.
Thank
Glad
you.
to have you. We will adopt the agenda. Has everybody had a copy of that? Do you have a copy of the agenda?
I have a copy.
Okay. Do I hear a motion we adopt the agenda?
So moved.
Seconded?
Second.
Seconded. All in favor say aye.
Aye.
Review of the, and approval of the minutes.
Before we jump in the minutes, would it be all right if I go ahead and read the notice of meeting as well into the record? Thank you,
I
sir.
always get in the way of that, don't I?
No, you did great. Notice of August 16, 2017 meeting of the Collection Service Board meeting was posted to the Collection Service Board website at August 8, 2017. Now on to the minutes.
Did we get the minutes in email?
Yes, sir. Yes, sir.
Okay.
Yeah.
I haven't had a time to read. On here?
Yes, sir. Go back to lab here.
Take just a moment and review these. Are there any corrections or additions to the minutes? A motion that we approve the minutes from the June meeting.
So moved.
Seconded.
Second.
All those in favor say aye.
Aye.
Motion carries. Now what have I done here?
We'll go ahead and jump into the budget report next. It should be number 3 on your iPad there. If you go to the menu, and then it'll be the next one in sequence.
What I do when I've done this?
Oh, yeah. Thank you.
It's done. Says done at the top.
Sorry.
Oh, no worries. I had to kind of work my way through it as well the first time. We'll move on to the director's report. We'll first start with the budget. You should have that in front of you there. And if you don't mind indulging me for a moment, I'll just do a quick explanation of some of those categories for the benefit of our new member, Mr. Holden. First of all, if you look at the very top left-hand corner, the top section, you'll have licensing revenue and case revenue, state reg fee. The licensing revenue and case revenue, that's basically Edison, where everything that comes in based on licensing fees and based also on the complaints, the whatever fines are assessed comes in at that line item as well. Now, the state reg fee, you'll see there's a reduction. That seems like a strange place to have revenues and then have a reduction there. What that is we're required to pay $5 per year per license and for each renewal, and we pay that to fiscal F&A, Finance and Administration. It's a workaround because Commerce and Insurance, they can't bill reg fees directly, so F&A does that for us. So it's a little irregular compared to your standard expense. So that's why it's itemized up there as opposed to down below, because it directly impacts the licenses themselves. There's a fee assessed there. And then the expenses are pretty self-explanatory. That top one is Edison expenditures. Those are email direct due to payroll concerns, the confidentiality of the payroll that would be assigned to each of those actions. So that's what that is. But basically, we have our revenues, then we have our expenses, which leaves us either a net surplus or deficit. And then at the very bottom, the historical trend, which tracks each year, each fiscal year, so we can compare that as well. So we can do a micro view of what's going on through the top two sections, and then kind of a macro view overall trending. So that's what we're doing there. So we'll just jump in what we have here. We ended the fiscal year in July, and this is where we reported for the end of the year. First of all, we'll just do June, and then we'll do the year itself. The revenues brought in, collection revenues for June, were a total of $28,975. The expenses were $18,250, which left us a net surplus for the month of $10,000. Now for the year, we had revenues that were $343,215, with expenses totaling $203,462, with a net surplus of $139,753. So as you can see, we're at a pretty good position as far as our budget's concerned. Did anyone have any questions regarding that?
Glenn, I think the license renewals are on every 2 years.
Yes, sir.
Is that right? Is this reflect an off year or a positive year, or are they all mixed in now?
They're all mixed in. We have some that have a 2-year licensing cycle, like our land surveyors. They're all due per every 2-year cycles. But here it starts at when they are approved at their application, 2 years from there. So it's all staggered.
Here, just real quickly, $6,000 revenue means that there are at $5 apiece, or $6,000 expenses. That mean there's 3,000 agents or 1,500 agencies? How many agencies are licensed do we have?
So I don't have the number off the top of our heads. We can run that and give you a good breakdown. But that includes duplicates that someone wants. It's any time a license is printed, we're charged that $5. So, but we'll get you numbers as far as the licensees so that you can get a good feel for them.
I'd kind of like to know a
Yeah.
running number about how we do each
Sure,
quarter.
we'll include that,
Yeah,
yeah.
we can provide that for you at the next meeting. That'd be fine. Any other questions?
Not for me.
Mr. Kopchak, just from my knowledge.
Yes, sir.
Looking at February 17, there's a negative 23,000.
And that was I'm glad that you pointed that out. We covered that once before. What we had is we printed too many solicitor cards, and we had to do a refund. So that's why we had that big hit on that month. So and that was articulated in I believe March's meeting, and you can go back as well if you like and get further detail, and I'd be happy to expand if you like as well.
I think that hit January's revenue at 73,000. So if you take the 23 out, you blend down to more like a 30,000 month for 2 months, or 25,000 a month for 2 months.
I see what you're talking about. Yes, sir.
And if I could add, it isn't just a printing, especially just for some background on the additional cards that they're allowed to ask for when someone is actually looking out for business. Then it's common for those that are out of state that have more licenses than in Tennessee to kind of misjudge that and ask for more cards than what they really need and what the statute requires. So we've added the text, I guess, the best we can online to kind of emphasize you don't need this for all of your employees, but we've had it at least twice with a large refund where they've asked for hundreds of these cards, then thought it through, or someone in the office questioned and said, oh, no, we didn't mean to do that. And so we, of course, then,
They got one for each collector,
yeah, they don't need that.
not each salesperson.
If you go to our website too, on the front page, we've since added that banner that Director Gramusio was referring to, trying to clarify that a little further for our out-of-state folks. Good question, thank you. Any further questions? Okay. There's just a couple more items. First of all, I'd just like to introduce our new attorney to you. Ms. Martin will no longer be responsible for sports, so Ms. Ashley Thomas will be covering the responsibility. She's not new to Commerce and Insurance, but she will be new to this board, so she's very skilled and will handle all board business aptly.
Thank you very much. Good morning to the board. I do look forward to working with you all. If I can be of any assistance in any way, just let me know.
Welcome, Ashley.
Thank you.
Just a couple more things to note as well that I just want to kind of get out there. First of all, something to be thinking about, statute 6220-104E states that the board shall annually select from its members a chair, vice chair, and secretary. No member of the board shall hold more than one such office. So in response to that, maybe next meeting, or whenever you're prepared to do that, but we can also wait until next meeting to have a chance to kind of think about that, cogitate on that a little bit, and then come back with the selection of those three.
So we will have an election of officers at the...
October 11th meeting, yes, sir.
Do we submit nominations prior to that?
You can do that at the meeting. So whenever you're ready, you can do it right then. Yes, sir. Yeah, and if you wanted to do that today, you'd be welcome to do that. But if, I just wanted to give you the opportunity if you wanted to wait as well. So
maybe Chip will be here in October, and we'll have a...
that sounds
We'll
wonderful.
have a...
All right. And then
Good
the,
state.
Polling for him.
he's campaign manager. And then one more item, and then we can put the director's report to rest, was Director Gramusio and I were talking about anonymous complaints. In the past, they were never referred, and so we are now opening each and closing if no info provided. Helps us track the volume. And the reason why they were being closed, if there was no information provided, they were just kind of out there. We didn't know, nothing really we can call back, couldn't follow up on them, nothing for us to go on, so we just closed them. But the reason why we're going to open them and then close them is just so we can track the volume. So just so you'll be aware of that.
Will there be a count in our report in the future? If you're opening it, then do we have to see it?
If it's open and closed, you won't see it. But if it's something that's being brought before the board for review, as per usual, then those will
We don't
continue
have
on.
to approve closing the
That's
case?
correct. You would not, no.
Good, okay.
And the board is made up of 5 members,
Yes, sir.
and there's only 3 of us here, and Chip is, of course, not here.
Correct.
Is there a 5th to be appointed soon?
Angela Hoover is still in that
Oh,
role,
okay.
so Mr. Holden, he's filling in for Trinkler. And so we have our 5, and then, of course, 3 out of 5 will constitute a quorum. So that'll be the board thus far. Are any other questions regarding those items?
How often do board members revolve off? Is it every year, every 3 years? Once you're appointed, how long is the appointment for, I guess is the question.
They're for 3 years in this program.
3 years?
Yes, so, yeah. They do vary by programs, but until you get your thank you letter, even though you've expired, you're still, as we know, with Elizabeth, that was very kind of her, yes, continue to serve, yes.
Okay, thank you.
Hey, legal report? Has everybody had an opportunity to, Josh, probably you haven't had a chance to look at the legal report?
Yes, I have looked at this.
Yeah. Questions?
On number 14, I had a question. I'm just curious, who was the caller from the payday loan company, or was this a first-party collection on number 14? Way ahead.
Let me have a chance to look over this real
Yeah,
fast.
absolutely.
I was just doing that. Can I just quickly note that some things that were included, and I can't remember if I sent it to you or not, but the rules, the red line rules, I did, didn't I? Okay, just want to make sure. Okay, we're going to cover that after the
Yeah, there's
cases.
a lot of
Okay.
those, yeah. Thanks for sending them up.
Yes, sir.
No, this is not this is a debt collection company.
I couldn't tell. In a way, it almost seemed like someone from the payday loan company called, but the loan had been assigned to an agency, and we know it was an agency that called.
Right.
Okay.
On number 8, or excuse me, number 9, is it okay to send out collection letters with a DBA letterhead?
I believe the rule is that it has to be registered with the board, so if we have the DBA name registered with the board, that's okay. And in this circumstance, they were.
Number 11, looks like that the complaint was confused about the provider's identity. If an agency is collecting for XYZ hospital, then the agency is required to disclose that in the letter, in communications with the debtor. Was that done? Respondent sent complaint a letter on May the 4th, 2017, with additional information, including the date of service and provider's identity. Had he not sent that prior?
I'll have to look at the initial notice letter. I can find that file right here.
Number 16, the case arises out of a consumer complaint disputing the validity of a debt. Respondent completed an investigation and closed the complaint's account. Suppose that's okay. If they don't provide the information in 30 days, they just close the account. I guess that's all right.
And then for, what was that you asked about? I think it looks like there's a misnumbering, so we don't, oh, never mind. So it's number 11, and yes, the name of the provider was on the initial notice letter. When she asked for, when she asked that the debt be verified, they sent additional information such as the date of service.
Correct. Questions on the legal report?
It's not really a question. I guess it is. Number 18, that's the represented. That was such a scam, I believe. Is there anybody we can forward the level of scam that it is on for any kind of additional work or a prosecution? I don't know. I've never heard us talk about doing that when somebody was just this scammed.
A lot of times complaints come through Consumer Affairs to us. I'm not sure on this particular one, since actually Shalina's case, and she's not here to talk about it, but if it didn't already come through Consumer Affairs, we can probably send it back there. A lot of times if Consumer Affairs thinks a scam is severe enough that they can get the Attorney General involved. That's probably the best guidance I can give at this point. I'm not sure who else we could send it to.
I was just wondering, because it seems pretty obvious it was a scam. We haven't talked about sending them forward. Do you all think there's any value in doing
I
that?
think it's awful, but if you don't know who it is, you don't know who it is.
Yeah, but that's part of the scam. I guess there'd be no way for them to track it down from this information. Curious. Thank you.
I'd entertain a motion to accept the legal report with, there weren't any changes, were there?
We have 2017-025-141. Recommendation is to close. Number 2 is 2017-033-941. Recommendation is to close. Number 3, 2017-026-771. Recommendation is to close. 017-028-791. Recommendation is to close. 2017-026671. Recommendation is to close. 2017-027-251. Recommendation is to close. 2017-022-021. Recommendation is to close. 2017-024-171. Recommendation is to close, as this complaint is outside the board's jurisdiction. Number 9 is 2017-023-461, and number 10 is 2017-022-071. Recommendation is to close. Number 11 is 2017-031-901. Recommendation is to close. 2017-0377781. Recommendation is to close. 2017-0377081. Recommendation is to close. 2017-039-971. Recommendation is a $1,000 civil penalty with formal charges authorized for violation of TCA 62-20-115B4 for unlicensed collection service business. Number 15, 2017-041-071. Recommendation is to close. 16 is 2017-034-991. Recommendation is to close. 17 is 2017-035-791. Recommendation is to close. Represent of 2016-066-921. Updated recommendation is to close. 2017, and then we've got an addendum at the end, 2017-040-481. Recommendation is a $1,000 civil penalty with formal charges authorized for violation of TCA 62-20-105A. Just,
Go ahead.
I think the addendum was added to the iPads after the after the legal report was sent out. So just want to make sure y'all had a chance to review that.
This was a debt purchaser out-of-state debt purchaser who made a call into Tennessee to collect the debt directly.
Yes.
According to the court, the Supreme Court, this is not an FDCPA violation, I guess.
Right, but they still have to be licensed within the state.
They have to be licensed
So
to do it.
we're doing it for unlicensed activity.
Ms. Shepherd,
Okay.
does the debt buyer have
Mr. Holmes, do you mind speaking in there because we're recording it, so thank you so much.
All right, let me see.
Yeah,
Like magic. I'm sorry, I'll repeat my question just so it gets on the record. Ms. Shepherd, does the debt buyer have to present proof that it actually has purchased the debt, or do we take their word for it? Do they give us an allonge, or do they give us an assignment of the debt? How do we know that they're a debt buyer?
That's just what they stated in their response.
Us knowing they're a debt buyer wouldn't change our position. It's an out-of-state person attempting to make a debt collection, a third-party collection call in Tennessee. So knowing that they were the buyer or not, I assume they represented themselves as a collection person.
I don't disagree with you. I was just, the FDCPA reference piqued my curiosity on that issue.
We're about to
and-
get into that big time, I think.
Legal report. Entertain a motion to approve the legal report and the addendum.
Of the report?
Second.
All in favor, say aye.
Aye.
Okay. I got it.
Fast hit library. Yeah.
Application review.
4A.
We're just going to go ahead and, while on the legal report, we'll just jump in and go ahead and handle the FDCPA line items, the rules, and the regulatory flexibility and analysis memo and the governor's questions regarding that. If you look on your iPad, 4A through 4D will cover all those items. So I'll let Ms. Thompson take it from there.
I believe that these rules and the answers to the questions were emailed to you all last week. If we want to just go over it, if you have any questions or suggested changes, we can talk about those. And once we've made a decision from there, I will begin the process of sending these as proposed rules. And the reason I'm going proposed rules first, it's a little easier. It removes the rulemaking hearing. However, if there's a petition from 10 people or an association with at least 10 members, we will have to conduct a rulemaking hearing.
Is that the only change to the rulemaking procedure?
The process, yes, it just removes the rulemaking hearing if we go the proposed route, which is what I'm doing now.
How do agencies or that are going to be governed by this know that the rule's been proposed? Do we announce it in any way? Do we send all the licensed people the information?
So there are a couple of ways. So what we will do, once these have been accepted and adopted by the board, we will send notice to the Secretary of State, and they will post the rules for people to review. They can look over the actual language that you all have adopted, and again, if there's any petition that reaches the level as required by statute, we would conduct a rulemaking hearing. If there is no objection to the language of the rules, they will continue to stay posted. They will become effective, and again, the Secretary of State will send out a notice. Now, the department will send out notifies to licensees that have signed up to receive notification of changes in their program. We usually will do that at the beginning to let them know that the board has proposed these rules, and we will do it at the end to let them know that the rules are effective.
Fundamentally, these rules only really apply to a debt buyer who is collecting on their own behalf.
Yes. These rules were drafted to be in compliance with the Fair Debt Collection Practices Act. As you know, I took these rules over from Laura, so she had begun the process of drafting them, and I tried to complete that as best I could while getting up to speed on the currently enacted statutes and rules, and then apply those questions as well. But yes, to answer your question shortly.
Agencies are already under the FDCPA, and these rules don't change the FDCPA, they just adopt it? Or
Correct.
or do they tweak the FDCPA in any way?
They do not tweak the FDCPA in that's a federal rule. We can't exceed that authority. It did adopt it to Tennessee regulations so that those debt purchasers would then be bound to those regulations. So it codified it in that way.
Is it word for word, or is it adopting amendments to the law as they currently it stands?
So what we did, we went through the FDCPA and we pulled the language from there that we could apply in Tennessee. If it exceeded the authority of the board, we did not include that. But if you look at the language compared to the FDCPA, the language is basically the same. I'm sorry, Lindsay, were you going to add something?
Yeah, I was just, because the FDCPA already covers parties who have been assigned a debt, but then after that recent Supreme Court opinion, which we discussed the last meeting, a debt purchaser is now exempt from the FDCPA. So what this rule does is, by enacting the rule in Tennessee, since we already require debt purchasers to be licensed, it would apply the FDCPA, which we could adopt by rule, to them as well.
The reason I ask my question is, regular licensees who are under the FDCPA for federal purposes, this rule also covers them because they're licensed by the board. So if there were any discrepancy between the federal, which they're covered under, and ours, by any level of interpretation, the regular licensee who's not a debt buyer is in a whipsaw.
Right.
That's why I asked my question. Does it really follow it?
And it does. And in the event there was ever any dispute between the two, the federal would control. But the language of...
For the regular agency?
For the regular agent, yes.
Okay. It overruled the state,
Correct.
unless you're in state court.
Right.
That's ugly.
So we could pass a rule that debt buyers had to comply with the Fair Debt Collection Practices Act.
To the extent we can adopt the provisions of the Fair Debt Collections Practices Act by rule.
Which is what these rules do.
But we can't make a rule that says they have to follow a federal rule. We have to make the rules so they follow our rules. Because
Right now, we've got, one of our statutes says that a violation of federal law is a violation of the board's law. So that's why we're enacting the FDCPA, because some of our licensees are now exempt.
I have a representative from the Tennessee Collections Association here. Becky, do you all get a copy of these rules and proposed rules? Okay. Would you let someone know then how to send you these rules as we come?
If I could, as a process, and that's with all boards, make sure that you go to the board's website, and at the top right-hand corner, almost under Contact Us, there is a Get Notified. That is how all licensees register to get emails. This then is, and only important emails go out. This isn't a, junk kind of stuff. So you want to make sure to get that. There's just no other way for us to reach out to the individuals in this way. Even if you're not a licensee but interested, you would get that. Thank you.
where are we in the process? Are we down to the regulatory flexibility addendum yet?
So what I need from the board, if you all have reviewed the language, if you don't have any suggested changes to the language of the actual rules, if you'll look towards the back, I'll give you the page number. Give me just a second. So page 10 of the rules, they do have proposed answers to questions that are asked by statute. I've proposed some answers if you all have changes to that. So we'll need to adopt all of this, and I'll begin the process of posting that and getting these rules passed and effective.
I have a question.
Yes.
Over the years, this has been one of my favorite questions. Number one, the response is, the proposed rule change sets forth standards of practice for debt purchasers and or companies who purchase debts of another. Do we now cover banks?
I do not believe so.
No financial institutions
No.
are exempt from our laws
Where?
by statute. It's one of the exemptions to licensing.
Banks can buy debt and not have to comply with FDCPA.
Or Tennessee license.
Yeah, yeah.
I'm not sure about the FDCPA because that's,
Oh, they're debt buyers.
right.
Banks buy debt all the time.
And to Lindsay's point, that statute is 103A4 that does exempt banks. Correct.
Thank you.
Ms. Thomas, may I ask a question about the specific language of the proposed rules here, if I may? And I'm looking at, so that everybody can follow me, I'm looking, and I'm just reading 5-.02 and 5-.03. Just reading those two together. First two after the definition section. As I read 5-.02, we're talking in that rule about a debt collector communicating with any other person other than the consumer for purposes of acquiring location information. And we'll talk about that there. When we drop down to 5-.03(2), say that a debt collector may not communicate in connection with the collection of the debt with any person. So I'm seeing one rule that says we're saying what a debt collector needs to do to communicate with someone other than the consumer, and then we drop down, and in the rule below it we say that a debt collector, as I read it, I'm asking for clarification because I know I've probably got this wrong, but we're saying that a debt collector may not communicate in connection with the collection of any debt with any person other than the consumer.
Right, and my understanding of .02 would be you're communicating with that third party simply to get, I guess, identifying information about the consumer for the debt, but you're not going into the details of that debt with that third party. So for example, I could reach out to maybe Lindsay to try to obtain a phone number for Matt, but I cannot tell Lindsay exactly what the debt is that I'm trying to collect.
Or that you're even trying to collect the debt.
Correct.
5-03 sub 2, should we say, or consider, and I'm just asking the question, would there be merit to saying, except as otherwise authorized herein, a debt collector may not communicate with any other person? Because it sounds like we have authorized some communication with another person, with a third party, but it's got to be for the limited purpose of acquiring location information.
I think that the addition of the language except as otherwise here and authorized, I'm fine with. If the board elects to include that, I can make that change.
I may have just given everyone a headache, I don't know.
Makes a lot of sense to me. Yeah.
It makes a lot of sense. Thanks for reading it that close.
If we go through everything, we can adopt it as one motion. It's probably easier that way.
Other changes, questions, comments?
Thomas, I'll take up the gauntlet again in 5-.07 regarding validation of debts. In subsection 4 in the notice provision, the purpose of this portion of the rule is to set out some things that it's okay to send out. Notices that a debt collector can send out without getting in trouble. By the Internal Revenue Code, the GLBA. That in their federal or Tennessee law, would there be any benefit to adding Title 11, the bankruptcy code, in there? Because that's just a common situation where the bankruptcy code will require a notice to be sent. And we've got federal law in there, so we've got a catch-all. But that's going to be one that is going to interact with many consumers. If they've got a debt that needs to be collected, then they may be filing a bankruptcy petition, and they have to receive notices from someone under that. As a debtor, for instance. they may have to get bankruptcy notices. So I would throw that out to the board and solicit comment on that.
Source you said you wanted to add? Title
Title
11
11, the bankruptcy code
of Tennessee?
of the federal law.
Federal law. Okay.
And to your point, you're just wanting to specify that specifically in that section, because like you said, there is the federal law language that is a catch-all, but if the board sees that it's necessary for the consumers to have that specifically in there, of course, I can add that.
It may, just to the extent to remove any potential for confusion or, I agree, it's got federal law and bankruptcy code's a federal law, but certainly that.
Certainly makes it easier for them.
And just for clarification, those changes are fine as long as they don't exceed the federal law. And so, like I said, I think the federal law language that's there currently does catch that, but if the board sees that it's necessary to carve out, be more specific to Title 11, I can definitely add that language.
Personally agree with it. I think more is better than less.
Especially in this case,
Yeah.
yeah.
Okay.
Because there's so much opportunity for words I use to describe the kind of litigation that comes from attorneys who file a suit, ask for less than the cost of the defendant. Anything to alleviate with clarity that kind of action is nice. Bandits. We'll call them bandits. Not slighting the profession.
I mean, that's a word, because that's the word I'd use.
Hey, Josh, good work there, buddy. Anything else that you like or have noticed?
I didn't see anything else.
All right, I would, you ready for an motion?
Yes, and like I said, there was the flex memorandum that kind of spoke to the impact of the rules on small businesses and then the proposed answers to the governor's questions. So if there are no concerns or changes to that language, I think a motion will take care of it.
And a motion?
So moved.
Moved and seconded that we adopt these rules. All in favor, as amended and changed, all in favor say aye.
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 We need to do a roll call vote, if at all possible, just by nature of rulemaking, it will require that piece. So if you don't mind, I'll just go down the list. Mr. Holden?
Vote in favor, aye.
Mr. Howard? Mr. Howard?
Aye.
And if we can note, we have 2 members absent, Ms. Hoover and Mr. Hellman. Thank you, gentlemen.
And so from here, what will happen is I will send these to the Attorney General's office, who will review them for constitutionality, and she and I will go back and forth with any of those edits. If it's not substantial, we'll move on from there. If it is a substantial change that she's suggesting, I will come back in October with those changes, and the board will look over it, and we'll have a new vote based on those changes.
Number 5, next check.
If you'll notice on your iPad, there's 3 parts to this, and hopefully I didn't make this more confusing than necessary, but part 1, 5, is just basically a summary, basically the short of the long, trying to get right at the heart of what the issue is. And then 5A and B are the supports for reference. You have the financials and then the application. So if you would, we had an auditor look at this application, and he did a really good job, I believe, in summing it up. So if I can just maybe grant you a little bit of time here to read that and go over that, and then with the supports they're provided, and then we'll
What
discuss.
page or where are you on?
Number 5, page 1.
His memo with a
That's
photocopy
right.
of the letter
That's
highlighted.
right.
Okay.
And then
Thank
the
you.
supports are 5A and 5B if you wanted to get really drill down and look at those same items. For a better look at their financials, you can go to 5A. It's a
Distributions of 312 and 322,000. Down on the credit line to take money out of their own company. So they would draw it that way as a partnership draw.
The crux of it is they say they have no clients, but they purchase these checks within 30 days, so obviously they need money to cover that purchase, in the interim there, that 30 days.
Pretty healthy revenue, 2.7 million, almost 5 million in 15. Collection income in their revenue statement. Hint, hint. It would seem that they're a debt buyer that collects on their own purchased accounts.
That's right.
Absolutely.
I
think this is a UCC question.
Just a friendly reminder that specific financial information
That's good to know. We've done that in the past. Apologize for that. Because we see financials when we're reviewing them. And we've discussed things like deficit equity and insufficient trust accounts. But we're not even supposed to talk about that out loud.
just read the statute.
One way is if you don't say the name of the company that you're looking at and just,
That's
Yeah.
already, that's
For
in the
licensing,
agenda.
I mean, that's kind of in the agenda. Good to know. Notwithstanding their financials, they're a debt buyer applying for a license, it would seem. And since they don't have any trust account, even though they are their own client, effectively, they don't collect on behalf of another, so having a trust account wouldn't necessarily, they should at least show it with a zero. But they don't have that.
If, however, the check doesn't qualify to be purchased, then they still take ownership of that check. When it's paid, if it's paid, then that money has to go to the client.
It is a trust account.
So it is a trust account matter, and I think that they would be, under the statute, be required to have a trust account.
Question in front of us.
We'll just, it's a general application review. Obviously, there was problems here. It wasn't something that we could just approve. So, and due to the abnormal nature of the arrangement, we wanted to make sure that the board, with their expertise, had an opportunity to weigh in to see, after deliberation, if we need to go even further. You know, if we need to not just deny it, if that is the motion, but if it, we even move towards, if it becomes an issue, even towards revocation.
Licensed collection activity,
Yes, sir.
yeah. What do you think?
Yeah, they are licensed. They are like, this is a renewal. This was a renewal. That's right. That's correct.
I think that, based on the Supreme Court ruling, as a debt buyer, they still have to be licensed in Tennessee.
And they are.
They are licensed. This is a renewal.
So our question is now is whether or not we're going to renew their license. That's correct. And they don't have a trust account. according to this, they don't. They say they don't need one because this is their money, except when they don't buy the check. Then it's not their money.
At 30 days.
If they collect on a check they didn't buy, they're holding someone else's money by their own description.
Having a trust account would be to the benefit of their customers and clients, and the administrative burden of having a trust account is not a difficult hurdle.
Also a licensing requirement, so that, you have to show that it's.
I feel like that because all of the collections that they do are not for their own book of business, that they are collecting money for their clients on occasion. Have a trust account, they don't meet the qualifications to have a license.
That doesn't even go to the issue of not adequate equity to support the trust account. I mean, I believe somewhere in our rules or statutes, you can't have negative equity and get a license. You have to have positive equity.
That's correct.
Yeah, can't.
We want a motion to deny the renewal then? Is that?
I would entertain a motion to deny the renewal.
So moved.
Second?
All moved and seconded that we deny the renewal of this client. All in favor say aye.
Aye.
Thank you, gentlemen.
Will you provide them information
last-
that they can reapply with?
Yes, sir, we will.
Okay.
Unless there's any new business that you'd like to introduce, that was all that we had on the agenda.
That's the only business that I have. I would like to make an announcement that between now and the next meeting, Glenn and I will be going to Washington State, Bellevue, Washington, for the NACARA meeting, and there might be some oysters eaten.
We didn't vote on that last time. We just said go to the meeting. We didn't vote on oysters.
So we'll come back with a report of how much difficult and work we put into that meeting. So
we get a full report.
yes, and thank you, Governor, for allowing us to enjoy. Being no other business, we stand adjourned.
I need a motion.
Moved, we adjourn.
Thanks, sir.
Motion been made and moved that we adjourn and seconded, and what
Thank you, gentlemen.
we don't need a motion to adjourn.
There you go.
Thank you.
Who gets this piece of paper? Great work.